You yourself are on trial to an extent because you're being watched by an audience throughout the day. You're being critiqued by the jury, by the judge. If you're not prepared, they're going to see it. You're on stage for 6 hours, 5.5 hours every day. You've got to have everything down. You've got to have your script, so to speak, there. You've got to be ready with questions. You've got to be ready with your next witness. The other thing, the other mnemonic for trials, KISS, K-I-S-S, keep it simple, stupid. You want to be real simple in what you present to that jury. You want to present evidence to what people consider to be the lowest common denominator. The least intelligent, the least aware, the least observant juror has to be able to understand what you're telling them. If you have a complicated case, you've got some big problems because you should be able to explain that case in very simple, understandable terms. I think it's very difficult for anyone else, no matter how talented they may be, to beat you or to win their trial if the facts are on your side. Because all you really have to do is get those facts in. The jury, it's been said, and I think it's correct, pretty much makes up their mind even before closing argument. I don't know that many closings will convince a jury to go the other way. You still want to give a good closing. When you have medical records, make sure you read every single page. Whatever goes into evidence at trial, you're going to know beforehand, at least on your side. Get those exhibits prepared. Read every single page, every single line. Don't leave it to a paralegal. Don't have someone else summarize your depositions. You've got to know these things. You've got to know what's in there. You've got to know what might be used for you during trial, what might be used against you during trial. You've got to put that time in. If you win every case, you're nowhere near as ready and experienced as someone who's lost a number. If you are involved in your trials, if you care about your trials, and if you don't, you shouldn't be trying cases. If you really care about those trials, you're going to think about those losses for a long, long time. You're going to analyze them forever. You did something wrong. I've heard people say, I did nothing wrong. I tried a perfect case. You didn't. Either you misjudged it, or it might even be down to picking the wrong juror. Because no matter how good your case is, you're not going to win if the jurors aren't at least amenable to hearing what your side is about. If someone has a prejudice against your case, it's not going to happen. The OJ case, that was done after the jury was picked. There was no way the prosecution was going to win that case. That was a done deal because it was the wrong audience. They weren't going to accept anything the police had to say. You have to pick the right jury, or at least you have to make sure those that could harm you are off the jury. It's great conversation. Let me ask you what you think about this case right away. They're going to talk to you. You should be able to explain the case to anyone within a couple of minutes. You should know your case that well. Get feedback. Listen to what might be wrong with your case. Because you start to get in love with your case, and you may not see the weaknesses. That's what focus grouping is about. And I have to say, I have always found things come up in focus groups I just hadn't given enough consideration to. It's always been enlightening, and it's helped. You have to get your act together. As trial starts to appear, that weekend, you're not going away partying. You're focusing on your trial. You should always say to yourself, I really wish I had a little more time. You're totally into your case. You're clearing the decks for what's going to happen. If it's a 1 or 2 day trial, the decks don't have to be clear. If it's a number of weeks, the family stuff has to be put on hold. Everything has to be put on hold. Bills don't get paid. And that's how intense you will be during trial if it means something to you, and it should, and if there's anything at stake, and there should be something at stake. The heading for this is Plaintiff and Defense Tips. I'm trying to cover both to an extent, but I do mainly plaintiff's work. One thing I can say as far as preparing and being ready on the weekend, that's not something the defense lawyer should ever do. Just do not prepare. One thing you don't want to do is have a juror on that jury that you at one point didn't like. At least you want to try that. Sometimes you have no choice. But if there's someone who you say to yourself, I like them, but, or I have my reservations. You know what? As the trial gets longer and longer, you're going to be kicking yourself. Go with your gut. Ask your client also, what do you think? When the jury comes in, I look at the jury. I'm observing them very, very carefully. I'm observing how they walk, how they're dressed, even more so when they're called to the front. I'm looking at them every possible second I can. And it's going towards the gut impression. You want to see how they react with other people. If they get along, if they're staying away. If someone is too isolated from the rest of the jurors before they go in, guess what's going to happen when they're up there deliberating? I always thank them. I always use thank you. I always use please. I never talk down.